Hello, everyone, and welcome to the Ethics Series webinar, Understanding the Bar Admission Form and the Moral Character and Fitness Application. This series is brought to you by the ABA Law Student Division, the Center for Professional Responsibility, and the Young Lawyer. As a reminder, ABA membership is free for all law students, and law students also have the option of upgrading to a premium ABA membership to enjoy these exclusive benefits for only $25 per year. We're going to start with introductions and then kick off the presentation. So my name is Meredith Small. I'll be serving as your moderator today. I'm a 2L student at Harvard Law School, and I'm also the Law Student Division's liaison to the Center for Professional Responsibility. In the short time that I've been an ABA member, I've found it very rewarding. I've been able to attend various conferences and trainings and meet all sorts of impressive students and professionals from all over the country. Joining me today are Dennis Rendleman, Ethics Counsel with the American Bar Association, and Tom Clancy, Secretary of the Illinois Board of Admissions to the Bar. So Dennis, let me pass it off to you and you can introduce yourself and take it from here.
Thank you, Meredith, and hello, everyone. We're going to explore some of the issues and questions that arise surrounding the bar admissions and character and fitness process. Obviously, because we're talking nationally, we won't delve into some of the specific issues that arise in individual states. Those types of things are things you'll have to investigate on your own, and we're going to not take you on a step-by-step, line-by-line process through all the various forms that are involved, but there is a resource, the basic Bible, if you will, for bar admissions, and that is published through the National Conference on Bar Examiners. It's available on this website in an electronic form, and I believe you can also download a PDF of it. This is where you go to find the information you're going to need regarding your individual state. But in a general sense, there are various commonalities that arise, and it's important to you to gather the information at an early stage in your career or potential career. Now, my background in this area is long-standing. In my earlier life, I was counsel at the Illinois State Bar Association and worked with the Committee on Legal Education and Admissions to the Bar. From there, I went to the University of Illinois at Springfield and served as pre-law advisor. And now as ethics counsel here, issues relating to admissions and character and fitness arise, at least tangentially, though do arise through Professionalism Committee, which I previously staffed. So I've been involved in this for much of my legal career and have continued to have an interest in these activities and these issues. Now, some of the resources, in addition to the Bible, can be found at these web addresses. There is a model bar admissions form and character and fitness application available at these websites through the National Conference of Bar Examiners. Not all states utilize the same form, but increasingly there is uniformity and use of not only the application on a state-by-state basis, but there's also increasingly the use of national investigative and review forms and services available to take some of the administrative and investigative burden off individual states. And there is a long history of bar admissions practices, going back to Lincoln's day, where to be admitted to the bar in Illinois, Abe first went in March of 1836 to the clerk of Sangamon County to register himself as a man of good and moral character. And this was after he had been reading the law for a couple of years with John Stewart. And then after that, he passed an oral examination by a panel of practicing lawyers and appeared before two of the Supreme Court justices at the time, and received his law license in September of 1836 and was enrolled before the Supreme Court in April of 1837. So in a somewhat primitive way, Abe's admission to the bar was very similar to what you will be going through seeking your admission to the bar. Now, the ABA and the NCBE have various standards, and these are found in the front of the book, the Bible that I referenced earlier, that seek to give a philosophical basis for this process. You know, as you can see on the slide, the purposes concentrate on, as does the entire disciplinary admission process, protection of the public and the system of justice. And the goal is to ensure that when you are going through this process, you understand what is expected by the bar examining authority. Primarily, the goal is to ensure that because lawyers are agents of their clients and agents of the court, that they are honest, trustworthy, diligent, and reliable in the performance of their duties in representing clients. Some of the types of conduct that are suggested to be considered in the standards for character and fitness include some of the things you would obviously suspect. And again, I'm not going to repeat what is on the slide, but there are things that you would expect and that you would, in seeking to hire a lawyer, expect the lawyer to demonstrate. Now, these are phrased in the negative, so there are things that you would expect a bar applicant to have not engaged in. Similarly, they delve into matters that go beyond the professional, but also get into personal matters and prior professional activities and matters. But there is controversy. One of the ongoing and particularly current critiques of the character and fitness process is the question of, are these characteristics actually predictive of an individual's moral character to be a trustworthy lawyer? Recently, Professor Leslie Levin has been doing some scholarly research into the standards and traditional character qualities that are identified, that have been identified, and you see a citation to her article here. But one of the most significant findings is that few elements of an applicant's history predict or correlate with eventual attorney discipline. And that is something that is of concern to the both disciplinary counsel and the bar in general, because if we are looking at what we should be considering in admitting lawyers, one of the primary goals is admitting lawyers who will, or admitting individuals to be lawyers, so they will not be engaging in conduct that could result in subsequent lawyer discipline. And so far, the research is showing that there are no clear correlations between the standards for character and fitness and subsequent lawyer discipline. There were very, very weak correlations, just slightly better than random, on being male, graduating from a quote-unquote low-ranked law school, and I'm not sure what low-ranked and the quality of the rankings are to begin with, having a low class rank or low grades, and having credit problems or high student loan debt, which is a whole other topic for another day. There were no correlations between bankruptcy, mental health treatment, substance abuse, or academic dishonesty. And all of those areas are significant issues that have been going on for debate, particularly questions that exist on character and fitness forms regarding revelation of mental health treatment. There has been a great deal of debate about the impact of that question, those questions, on individuals who decline to seek mental health treatment while in law school, because they may have to reveal it on their character and fitness application. There is significant issues in that area, and it varies from state to state. Some states are no longer asking those questions, but that is a significant impact. The same thing with substance abuse. We know that in the legal profession, substance abuse is higher than in other professions, but is that something that should be a determinative on admission to the bar? And finally, one ongoing issue is the question of revealing any type of criminal or juvenile activity that has been expunged. There, again, is no correlation with that to future discipline. Legally, something that is expunged does not exist, and what is the philosophical basis to have the character and fitness process, the bar admissions process, require disclosure of something that has been legally expunged? It seems to be rather contradictory and an intrusion into legal rights that are otherwise protected for the rest of the public. On the other hand, there is the general principle that disclosure of much of this information, whether it correlates or not, is a benefit to the public, increases public trust in lawyers, emphasizes to applicants the sense of responsibility that they have, and reemphasizes to applicants the expectation that is there for lawyers to be responsible and trustworthy. So it serves not only a symbolic role, but is akin to the lawyer's oath in emphasizing how important the lawyer judicial system and in serving clients is. But that doesn't mean there also aren't some hiccups along the way. Recently, there have been two anomalous opinions that illustrate some of the concerns. In this Jarrett case, the applicant had inflated grades on a resume and had failed to disclose certain traffic citations from out of state. And the Wisconsin Supreme Court reversed the bar of admissions and ordered a supervised admission based on conduct subsequent to law school. At the same time, in the Brown case, the Maryland court did flip-flopped exactly the opposite direction, where the Board of Admissions had recommended admission for someone who had inflated her grades and a prior earlier youthful indiscretion. It sounds worse than it was, a felony theft charge, and voted to deny admission. So you've got two different states, two different Board of Admissions, one going one way, one going the other, and the courts in each state reversing the boards of admissions. So you can see everything is very state-oriented. There are other cases that cause me concern. I've included some citations to other ones that you can review at your leisure, but the reasoning in some of them, I'll let you draw your own conclusions and let you discuss those in your own time. But one of the other problems is that there's an ongoing issue regarding the bar admission and law school admission. And increasingly, the bar admission process is also going back to review the law school admissions. And that requires you to be particularly attentive to what you may have disclosed on your law school admission and make sure that it is consistent with your admission to the bar and character and fitness forms. There have been times where people have failed to be as accurate in their law school admissions as they need to be on their character and fitness admissions, and may need to go back and revise and correct your law school admissions papers. Indeed, there have been some law schools, there was one in Georgia a few years ago that, as part of their orientation for new law school students, offered the students a chance to correct information that was improperly placed on their law school application, so that there would not be a discrepancy later on. Because for most states nowadays, if you are admitted to law school, for all practical purposes, you are treated as being governed by the lawyer's rules of professional conduct, and your behavior is considered to be the same as a lawyer's and expected to be the same as a lawyer's. So any misconduct during law school is going to be held against you or to be evaluated on your admission to the bar. So basically, what we need to do when we're going through all of this process is remember two rules. Don't lie, whatever it is. And if you did, don't deny it. display regret and sincere humility and shame, and that will go a long, long way to alleviate any impact that the misstatements, misconduct that you may have engaged in will appear before those that will evaluate you and your admission. Now, we have a special opportunity today to avoid any more of my talking head, though since you can't see me, I guess it's more a disembodied voice, to have a distinguished member and secretary of the Illinois Board of Admissions to the Bar, one of those people who gets to contribute to the final decision making in admissions to the bar. Tom Clancy's a distinguished lawyer, concentrated most of his career in personal injury and practice, and was active in the Illinois State Bar Association, was a president and there, and a longtime friend. And Tom, are you still with us?
Yes, by phone.
Lovely, thank you. And Tom, please for the crowd, just describe briefly what you do on the Board of Admissions to the Bar.
Well, in Illinois, there's 7 members of the board, each appointed by a Supreme Court justice, and really we're the arm of the Supreme Court as far as admitting people. Everything we do is to their approval. Well, the first thing that's most obvious probably is we run the bar exam, which means we rent the rooms and hire the proctors and rent the laptops and buy the pencils, unpack the exams mostly from the National Conference of Bar Examiners, for instance, on the multi-state, process all the applications. We decide what number will be the pass rate for our state for a given time period. And then there's the other administrative things. The staff does a budget, try to follow the budget, the board approves it, and we cooperate and do different things with the National Conference of Bar Examiners. We grade the test. We have professional graders in Illinois. I don't think every state is like that. We decide what some people get added assistance when they're taking the bar exam. We decide on that, whether law applicant might have ADHD, or they might be breastfeeding, or they might have some other psychological or physical problem that they need more time, they need privacy. Those go to the board, usually with a consultant. Believe it or not, there's professionals who consult in that area. And it's an important area for some people, maybe some people in this webinar. We approve transfers and waivers from other states. Technically, we're in charge of character and fitness, so that arm is very independent. So that rounds out our duties.
That was my next question, was what's the relationship between the Board of Admissions and the character and fitness?
Character and fitness, if you diagram the sentence, it would be an arm of the bar admissions, but a very independent one in Illinois. So we're technically their supervisor, but we don't do too much, day to day as far as supervising them. They have their traditions and their rules and very long-standing volunteers, committed people. Some of them have been on committees reviewing people and supervising for many, many years, and it's very well run, so we don't have much responsibility there.
Now, the biggest case of character and fitness that I recall over the past 30 years is, of course, the Matthew Hale case, which, for those in our audience, was the white supremacist who sought admission. But that's certainly an outlier type of case. What are the cases that you recall or that you've been involved in a general sense? Is there any trend or any similarity between them, or are they all sui generis?
As far as character and fitness, I would
character
say
and fitness and admission.
Well, I'd say the main problem is the character and fitness as far as people having trouble, and I can only reiterate what you already so clearly enunciated, that the people who get turned down in Illinois mostly they were not candid with the board in some way or other. Usually, I shouldn't say usually, sometimes it's a definite lie, purposeful. Other times it's other things that they got caught on. Maybe they forgot about it. And secondly, after they're caught, as you said, they don't take responsibility for their actions, and they don't seem, which, as you said, partly includes contrition and acknowledgement, and that has to be evaluated, I suppose, how much your contrition you show. You can tell by the way they apply themselves. So, switching before and after, it behooves a person to acknowledge their error, as you said, but also an acknowledgement and some kind of contrition for doing it, even if it was years ago, something you did in high school or freshman year of college. Orientation week went crazy, and you're a different person, but you've got to admit it, own up to it, and take the responsibility. We turned down maybe 1 in 200 applicants, which statistically doesn't seem like that much. I was trying to picture it. Sometimes in Illinois we'll have a room full of 1,800 people taking the bar, 1,500, 1,600, so that would mean 7 or 8 people in that room are not going to pass character and fitness. When you look at it that way, it seems like a lot, like 1 in each section are going to get turned down at least the first time. So in Illinois, we also have conditional acceptance for somebody perhaps who's rehabbing from substance abuse problems, or they're reorganized their financial situation, or they're dealing with a mental health issue that is continuing, but obviously we think is resolving or controllable or whatever. And so they let them in on condition and review it and check on their ability to control it. I should mention, Dennis, if you want me to.
Please.
On the mental health issue, in Illinois, we don't have a question about mental health. And there are cases that distinguish what you are allowed to ask. And when you read the cases, if the other states read the cases and filed them, they probably wouldn't put anything on it either. But basic rule is you're allowed to ask about some things with regard to mental health and not others. You can't ask about a diagnosis. You can ask about some forms of treatment. The main rule is if you use it as a I don't like to use the word excuse, but say a reason that you want to do something. Say you need more time on the bar because you have some kind of phobia. Well, that phobia then will be examined and reviewed and investigated to see if it's proper. Or if you say that you had a drinking problem in college and now that's resolved, or a drug problem, well, then you've opened the door for that to be thoroughly investigated. But it is not in itself a bar to joining the legal profession.
Thank you. I appreciate that clarification. I was not as clear as I should have been in raising that. So thank you.
I just I stopped before I tried to say the exact lines. It's worth anybody who has had counseling or whatever to study what that line is and see what you have to say and what you don't have to say in any state. But I think I'm sure I can speak for our board that we would want somebody to seek counseling to make their law school more enjoyable and more bearable and their life better, rather than hide it or frustrate it just for fear that you may be required to put it on some state's form, because it's just that's the better way to go.
Yes, exactly.
At least in Illinois.
Yeah, and I think that is accurate. Like I said, I think I glossed over that a little bit without giving the nuance and the clarity. And at this point, I think we'll open up for questions. Meredith, do you have any questions for us?
I do have several questions, and people can still submit more in the questions box, but we'll start with what we have. The first question is, in terms of previous employment issues, if someone was fired for misconduct, nothing criminal but just alleged misconduct, what kinds of documents would that person need to show, and what exactly would be investigated?
Well, in all likelihood, on the form, as I recall, there is a disclosure of prior employment. Depending on the nature of the situation, I think it's going to be something where you are going to want to disclose and elaborate on what the nature of the situation was. But it's going to depend on what the claims were as to how much you present, if you will, how many of the documents or anything of that nature from the employer. If you, in your narrative response, and this is going to be something where you're more than likely going to want to attach, do a C attachment to your application in order to elaborate on it. And Tom, jump in at any time.
The particular sometimes helps, even in a 50 state plus union. In Illinois, we don't ask if you were fired or discharged or had a problem, but we do ask very detailed about every job that you've ever had, even unpaid internships, unpaid jobs of less than 6 months duration, on anything temporary. So we will be checking with anybody that you reveal. But to answer your question, I would say that you would try to get ahead of the game. If you fear that it's going to say that they fired you for whatever reason, not showing up. I mean, if it was a high school job and you forgot to tell them you weren't coming in anymore, or more serious things, you should try to get ahead of it on your application. And I'd put a subsection that they don't even ask for, so they don't find it first. In Illinois, they will find out about it.
Yeah,
but
exactly.
I don't think nobody asks you to file the records. The bar will get the records.
Great. Okay, we have a lot of questions now, so let's jump to the next one, which is, given findings that mental health related disclosures do not correlate with later bar discipline and may prevent law students from seeking needed mental health services, do you anticipate the ABA recommending that states remove this line of questioning, and why or why not?
Well, I think we already kind of answered that with Tom's discussion of recent case law and the limitations that are there now. So I'd go back and check your state's form to see whether you're in a state that has revised their form or not. And then
I don't know what if the ABA has, how they.
Well, the ABA doesn't really recommend. It's more the NCBE that has the model form,
Okay.
as I recall.
Great. Next question is that, you said that law school admission applications must be consistent with bar applications. Does that apply only to the school that you attended or all the schools that you applied to?
Well, I'm.
Oh, go ahead.
Go ahead, Tom.
No, I shouldn't.
Okay, I'll
the
say.
Spirit of things, I would say you should get them all, because remember, they're going to ask for your friends. Investigators are going to talk to the friends or relatives, not relatives, that you've given them, and they might say she almost went to school with me here at State U, but at the last change, they will find out. I would go back and try to check on all of them, because it's just such an obvious thing. It's the first step of your legal career, and the laziest investigator will go back and look for some conformity there. But once again, at least in Illinois, I'm sure we would be forgiving for a proper attitude toward it. I think a young person coming out of college is not sure what they're going to do. They apply to grad school in English, they apply to law school, maybe they think they're going to get an MBA at night, so they're filing all these applications, a lot of time consuming during finals week, and you don't do it as carefully. I'm not talking about definite lies, but you forget about a job, you forget about some crime, and or you think that because it was expunged, I don't have to mention it. You're not in that legal mode that you're rising above the ordinary person in trustworthiness. So I think you better go back and check all of them to answer the question.
I've never heard it come up other than the school that you're graduating from. So,
I suppose nowadays when people apply to so many schools with the forms on the computer and their uniform.
I was going to say most of the forms are now done through the LSAC. Very few of the law schools have their own individual forms now. So it may be that going back through the LSAC and correcting it there corrects it for everyone. I don't know. I mean, at some point it becomes, ad absurdum, if you have to go back and change something you may have said in the essay that you sent to Podunk Law School because you misstated something about, some experience and at some point it becomes, overdone. Because also at some point, character and fitness people go over the top as well.
All right, next question. Are there any written guidelines for how people who have passed the bar but have not yet been sworn in can identify their job status on social media sites like LinkedIn?
You're a JD until you're sworn in. Anything else is a risk.
Easy enough.
Does that answer the question?
Next.
Yeah. Okay.
I think so. Next question, is there any guidance on states where medical marijuana use with a prescription is permitted despite the substance still being regulated by federal law, and has this come up as a fitness issue?
I've never heard of this situation arising.
It's still developing.
Yeah, I think it's too new, but if you live in Colorado or even Illinois, it's going to come up.
The issue is going to come up if you are coming from one of those states to a state that doesn't have any type of medical marijuana or recreational use. And that I haven't seen yet. The only case I know of is the only ethics opinion I've seen is in North Dakota, where a lawyer from North Dakota and who also lived in Minnesota, had medical marijuana prescription for Minnesota, and the North Dakota, I believe the phrasing was that it was a violation of the North Dakota rules, because North Dakota did not have. But that's the only thing I've seen. You know, if you're in a state that has, and you're applying in that state, I've not heard from the admissions authorities, but the disciplinary authorities are not pursuing anything, to my knowledge.
If it wasn't a crime in the state that you're doing it, I don't think Illinois would even ask you about it.
Great. All right, we have several questions about discrepancies between your disclosures for law school and your disclosures for the bar. So let me just give you a couple examples. One is, what if your bar disclosure is inconsistent with your law school application due to the fact that the bar disclosure asks for a broader disclosure? And another example is, if a conviction was not yet eligible for expungement and that was revealed on your law school application, does it make sense to get it expunged now? Won't the board notice the discrepancy?
I would be hesitant to try and delve into something too specific like that. I think the general rule of thumb is that the cover-up is greater than the crime, following the Nixonian principle that if you had just disclosed it, no one's going to take a second glance at it. If you don't disclose it, there's a tendency to think there's more there than there is. I go back to the title of Leslie Levin's article, The Folly of Expecting Evil. There's a tendency to think there's more there on something that's not fully disclosed than there ever really is. But I'm hesitant to get into anything specific, except to say, generally speaking, you're better off saying it's there, because then they can't ever say you were hiding anything.
If it's expungible, I think you'd expunge it in most states. You'd probably reveal it anyway, but at least the expunging would show that you respect the system and you want to have a clean record. But whether or not you could get it under your obligation, you have to read the question very carefully in your individual state or territory. Could I just comment on Lori Levin, Dennis? Meredith, just interrupt for 2 seconds.
Sure.
Go for it.
I did not read her whole article about the correlation, but I think the character and fitness, there's an awful lot of actions that a lawyer can take that will never get to the attention of a disciplinary and get into her study, where if somebody cuts a corner or lies to a judge or lies to an opponent, these things go on and they never escalate to problems with things. But this is what you're trying to emphasize, and I think you said it by making them answer questions, that you are in a different profession. You don't lie, even though you'll never, ever get caught. And your day-to-day practice is not supervised. Even if you're in a big firm, the partner will not know everything you do. We're trying to raise the standards of the people. So I think most people get in discipline because of substance abuse and from disorganization. So really, on the bar, character and fitness should be asking you, are you disorganized? Can you keep a docket? Can you keep a diary? But we don't do that. But I'm going to read that article more carefully and maybe suggest it for Illinois. And I say that smiling, but it isn't smiling. We should find out.
No, those are very good points.
Because those are the characteristics that get people in trouble and get their clients in trouble. I'm sorry to interrupt. Go ahead.
No, that's very good points, and I think that's one of the things that was unspoken, is that it's not just does character and fitness ask the wrong questions, but are there better questions that need to be asked that can focus on some of the issues that really are problems in the disciplinary. And certainly, as Tom knows, the thing that is most likely to get a lawyer disciplined, it relates to handling of clients' property, particularly money. And there's not that much in terms of either training or evaluation how people act as how lawyers act as the third party money holder. And that's a significant problem.
But perhaps we're getting into an area that's for bar leaders to deal with, not the individual applicants. So I'm sorry I interrupted.
No, that was a very cogent point.
Get back to the applicants who have individual questions. Sorry.
All right. Let me ask just a couple more, and then we'll wrap it up. And then there's a lot more questions than we can get to. And so what we'll try to do is to go through in the next day or two and post answers to the webinar recap page on the www.abaforlawstudents.com site. So if you didn't get your question asked, look back there in a couple days. Let me ask this question, though. A lot of people have written in with questions basically getting to, how small do the infractions, how big do the infractions need to be before you report them? So, for example, do you need to disclose parking tickets? Or someone else wrote, if something was disclosed to the law school and they essentially said not to worry about it due to the small degree of severity, is it okay to rely on that judgment when completing the bar admission form and moral character and fitness application?
Can I just identify, because there's probably too many answers. In Illinois, they ask every state that you were licensed in the last 10 years. And then they ask about outstanding parking violations, not past ones that have been dealt with. And I think some law schools are on a bad corner, and somebody will have 500 tickets by the time they graduate. That is not good for making the application. Do you have any outstanding? Explain the number of tickets, the authority, why you're contesting them, if you are, etc. So, once again, that would go down to the particular question, and I don't know what the NCBE asks in there, but if in too much doubt, I'd go all the way down, and it'd be a badge of honor that you talked about a small thing on your application.
I concur.
Next.
Great. And okay, we'll wrap up with this last question, which is what is the trend, if any, amongst character and fitness boards on social media? So, for example, this person suggests that social media contains a rich source of data that may allow a board to draw, useful inferences. But are there any requirements that applicants turn over access to social media or any of the content from social media?
Dennis, I would just say Illinois does not ask for your Twitter account or whatever, but I know at the beginning of some law school careers that the administration will warn you about your social media. And at smaller schools, I'm sure undergrads are advised. Somebody my age who's not active in social media is stunned. I'm talking about stunned, stopped in my tracks what people will put on social media for to be seen by everybody. And investigators know how to go into social media and know how to go beyond what's been canceled. I would caution you probably won't have to reveal it, but somebody's going to find it, and I suppose you should try to take it down as a first step. If people were very proud of their party prowess or where they were when they got blasted, but I would be very, very cautious with it. And if you haven't been till now, I'd definitely be all senior year very cautious with what you put up there, either in comment or in the absolute worst is the photos that people put on.
And
am I on the right track there?
I would just add to that that I don't think you have any spoliation of evidence issues, but more than the character and fitness, you've got employers, and employers, potential employers, have no hesitation about trolling for your social media. So you're going to want to go out there and scrub all your social media of anything except you're shaking hands with the Pope, because many people view that in a light different than you and your friends do, and it's worth doing that just because.
Right. It's probably not going to be, well, I shouldn't say probably. I can only say for one state, we don't ask. And so, like as Dennis said, there's no crime in trying to clean it up.
Great.
That's a very good question. That might be the best question of the day.
Tom will be back.
I'm sorry that I don't
media.
have the, I'm too old to be sensitive to it, but that was an excellent question, and anything we said in response to it is one of our more important answers as well.
Great. We'll end it there. A reminder to everyone to check out the webinar wrap-up on the ABA for Law Students website. And thank you, Tom and Dennis, for presenting, and thank you, everyone, for attending today's webinar. We hope you will join us for these upcoming ethics series webinars.